This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
Page 35. Remedies for breach. This actually came up in the last exam. And any student who did the last exam really has no excuse for not scoring 10 out of 10 for this particular question. Remedies for breach. There are two types of remedy. Well, there are two branches of law. This was something you read last night, isn't it? Something you were looking at last night, the background to the English legal system, the development of the English legal system. You did it last night. I did promise you a test on it this morning, but I think one or two of you may not have actually looked at it last night. So I'll give you the opportunity of looking at it again this evening, and we'll have a test on it tomorrow. The background, the development of the English legal system. But the English legal system did develop along two clearly distinct branches. There was common law, and there was another branch called equity law. And the courts of equity were different from the common law courts. The head of the common law courts was the Lord Chief Justice, and the head of the equity courts was the Lord Chancellor, and these were two different people. The common law courts established the principle that in the event of a breach of contract, damages would be paid. But damages is not always appropriate. And so the equity courts came into development, and they designed their own remedies available in equity. So we had these two separate court systems, and they were separate until 1873 to 75. And then they merged. And they're now headed by, I think, the Lord Chief Justice, but I may be wrong, it could be the Chancellor. They merged in 1875, and it's the same judges now who will say, yes, I shall award you damages, or damages is not appropriate, I'll give you an equitable remedy instead. It's the same judges in the same buildings, in the same structure, with the same solicitors, and it's all now administered by the one. So these two branches have now come together and are now part and parcel of the English legal system. But they were separate for many, many years. Back in 1610, there was a major fight between the Lord Chief Justice and the Lord Chancellor, and they physically came to blows. They physically fought about who should hear a particular case. The case was the Earl of Oxford's case. And because there was no central fund, no central purse from which you would pay your judges, your civil servants, we didn't have taxation, and so there was no central money available to pay people who were employed by the country. It meant that any dispute was settled either by the Chief Justice and his courts, or by the Chancellor and his courts, and any penalties that had to be paid went to these people. So the Chief Justice and the Chancellor wanted to hear the Earl of Oxford's case because there's going to be a lot of money in that. And so they came to blows. And the King, back in 1610, the King said, if there is a dispute between common law and equity, equity shall have the last word. Equity will prevail over common law. Equity, another word for equity, or an extension of the word for equity, is the word equitable. And another word for equitable is fair. It's a fair decision. Equal, yeah, but equal meaning fair. It's a fair decision. And fairness should take precedence. We had fairness yesterday, didn't we? Denning and the case Beswick and Beswick, where the auntie was not being paid by the nephew after the uncle had died. And Denning didn't know why. Denning had no idea why his decision was the right one. It's just that it was the right one. It was the only fair decision he could come up with. And so he said, Yes, I shall make the nephew pay the ante, but I'll then instruct the nephew to appeal his case to the House of Lords, or what is now the Supreme Court. So that's a very, very quick summary of the development of the English legal system. You need to learn or read more of that this evening, and we'll think about it tomorrow. So that's where common law and equity come from. The common law had their own remedies. The main one is damages, payable by way of compensation. The equity developed their own remedies, the fair remedies, because a monetary payment was not enough. It didn't serve the purpose of compensation. So, damages. Now, we talked about remoteness and measurement of damages already. And damages will be awarded if damages is appropriate. No matter what equitable claim you think you have, if a monetary payment is enough, then a monetary payment is what you will get. Action for price. There's no concept of measurement in an action for price. Sandra owes me £50. She's now refusing to pay me, so I shall sue her for £50. I shall just take legal action against her and demand that she should pay me £50. So action for price, there's no question about measurement or remoteness. It's just an obvious thing. Quantum meruit is a little bit of Latin, and you should be able to actually guess what quantum meruit means. What does quantum mean? Sorry? Yeah, and the amount. Quantum, the quantity, the amount. Meruit? It's almost the same as the English word. If you just drop the U out of it. Merit, yes, for as much as it is worth. For as much as it is worth, quantum meruit. And we got 3 cases quoted, and again, I'm only going to look at one of them. I suppose I should look at Planchet and Colburn, because that was about writing a series of articles about weapons. So I then could have asked you what other weapons cases we've had, but we'll not look at Planchet Colburn. We'll look at Hoenig and Isaacs. Hoenig and Isaacs. And this is a man who employed the services of a kitchen fitter. A kitchen fitter. He's going to fit a new kitchen. And the agreed contract price was £755. And Hoenig, the kitchen fitter, the Hoenig fitted the kitchen, said to Isaacs, "That's it done, there's my invoice," and Isaacs looked closely. One of the drawers in the kitchen units, one of the drawers did not open smoothly. That wasn't good. One of the worktops wasn't exactly level. That also wasn't good. And in a kitchen, it's not particularly unusual to have what's called a peninsula. A peninsula unit sticking out. So you put a chair here and here, and it's like a breakfast bar. Well, you don't often get pieces of either stone or wood which you can shape like that. So there's normally a joint there, and that's called a hairline joint. It's a hairline because you can't see the joint. It's so good and so tight and so precise. It's a beautiful joint. The hairline joint was bad. The hairline joint was obvious. It was clear. And so Isaac said to Hoenig, "I'm not paying. I'm not paying. It's a mess. The drawer won't open. The worktop's not level. And look at this. This is not a hairline joint. So I'm not paying you anything." So the kitchen fitter sued the householder, Isaacs, and it went to court. Now, what's the fair decision? We're in breach here. We're in breach. And non-performance and no exclusion clauses. Is it right that Isaacs should not have to pay Hoenig? Well, no. I mean, it's clearly the case that Hoenig has done work, and most of it is okay, And what's not okay can either be repaired or replaced. So what's a fair decision? What would be fair? Yeah, part payment. So the court said, well, how much is it going to cost to repair this drawer? How much is it going to cost to level the worktops? And how much is it going to cost to mend this hairline joint? And the answer was, it's going to cost £60. And the court then said, pay him £695. Isaacs, pay Hernig £695. You keep the 60, which you can then spend if you want, getting these minor defects sorted out. For as much as it's worth, quantum meruit. Those are common law remedies: damages, action for price, and quantum meruit. But it's sometimes the case that monetary compensation is not enough. If somebody's annoying you, it's sometimes not enough to be paid money so that they can continue to annoy you. You want them to stop annoying you. So you can ask the court, you can take this person to court and ask the court and say, can you help me here? Can you stop this person annoying me? And the court has that ability and facility to be able to do it. So these next few are remedies which have been designed by the courts of equity and are now continued into the combined equity and common law courts. Specific performance is the first. And specific performance, just in 2 words, specific performance says, do it. Just do it. You're refusing to do something or refusing to deliver something that you've promised to sell. Now you're refusing. And the court will say, sell it. You agreed to sell my car for 400. I'm now refusing. The court will say, sell it. Deliver your car and get the 400. So a specific performance is the court saying, Nike, just do it. Injunction, strange word, I don't suppose you've come across the word before. Have you come across the word before? Injunction in 3 words. Specific performance, do it. Injunction, stop doing it, don't do it. Or stop it, in 2 words, stop it. Injunction, most commonly we'll hear about injunctions in English courts, newspapers. You most commonly hear about them because somebody is building a wall so close to your property without permission, so close to your property that they are depriving you of light. Your room is now dark because this wall is too close to you. And if you see the wall being built, you can appeal to the court and say, will you stop them building this wall? They are depriving me of my light. And the court will grant an injunction and say, stop it. And possibly even knock down what you have already built. Injunctions also apply where there was an article in the paper I read a few years ago now about a neighbour and their immediate neighbour above them was a young girl who liked listening to Britney Spears records. And 6 o'clock in the morning when the baby woke up, she'd immediately turn on Britney Spears before she started attending to the baby, and she would play Britney Spears, boom, boom, boom. And she did this until the baby eventually went to sleep after its last feed at 1 o'clock the next morning. And it was day after day after day. Noise, thumping, continuous, annoying. So the downstairs neighbour got the local authority in, they measured the noise levels. The local authority then takes this woman to court and says, you're playing your music too loud, you'll have to stop it. She doesn't believe them, so the judge, the local magistrate, says, stop it, injunction, stop doing it. But she didn't, she carried on. What happened next? Jail. Jail. Can you imagine going to jail because you like Britney Spears? Really? So injunctions are granted where somebody is annoying someone else, stop it. Or where they're building a wall, knock it down. Rescission. You'll find rescission is in your Superman list. In your list of cases, it says rescission in your Superman list. Rescission, to rescind, I told you yesterday, to rescind is to put the two contracting parties back into the position they were before the contract started. Restoring the partners to their pre-contractual position. The effect, why is it in your Superman list? Well, if you ever saw the film Superman, I think probably the original Superman, do you remember that Lois Lane was caught in the San Andreas fault which opened up and Lois, do you not remember Lois's car disappeared and then it started closing over and all the soil and the dust was closing over and Lois, in a last desperate effort, called out to Superman. She said, Superman. And he was 18,000 miles away. And Lois, and he flew there, and he went down to the San Andreas fault where Lois's car was now buried, and he said, Lois. Do you remember what happened next? Shot up into the atmosphere. And went round the earth, and stopped the earth from turning, and he went so fast he started turning backwards, and the soil came out, and the car reappeared, and Lois was all right, and Lois Lane was saved, restoring her to a pre-accident position. Rescission. Rectification. What's the verb to rectify? To put right, to correct. It's the same root as the word correct. So it's to correctify.